Chapter 2, Disputes and Dispute Settlement. There are three different types of alternative dispute resolution: negotiation, mediation, and arbitration. Negotiation is the simplest of the alternative dispute resolution because it does not involve outside parties. Mediation uses an impartial third party to settle disputes and is future focused. 3. Arbitration uses an impartial third party as well, but this person, the arbiter, decides on an award for the wrong party and is not future focused. How to establish alternative dispute resolution to help businesses be more successful. 1. Avoiding large costs from litigation. 2. Avoiding the lengthy time going through the court system. 3. Lessen the disruption to the business and its ongoing operations. 4. More control to those involved in final results. 5. Decision focus on compromise for parties involved. 6. Typically result in a more concrete decision as people are willing to stick to a decision they are involved in making themselves. 7. Can result in a less severe outcome than going through litigation. 8. Keep businesses' relationship intact by attempting to satisfy both parties. 9. Help parties deal with dispute constructively.
Chapter 3 in our textbook is all about business ethics and social responsibility. According to the textbook, leaders should establish a code of conduct to help ensure that all employees clearly understand the goals and values of the company and the desired professional behaviors expected. If ethical business practices are not followed, a company's reputation could be tainted. Corporate social responsibility states that businesses should participate in the global effort to help make the world a better place by using methods such as volunteerism, monetary donations, and establishing environmentally friendly policies. Socially responsible businesses tend to be stronger organizations than those that are only in the business for profit alone. Establishing ethical business practices and participating in corporate social responsibility can help a business be successful. For one, it helps boost company reputation and credibility because of increased confidence by investors, consumers, and current and future employees. Consumers and investors want to invest in companies that want to make an impact on the world and benefit society as a whole. Consumers also perceive a business's products in a more positive way when the business is deemed ethical and socially responsible. Investors want to ensure that their investments are protected from unethical decisions and behaviors. Establishing ethical business practices also improves positive employee relations, increased retention rates, and talent attraction. Employees want to work for companies that are ethical decision makers, use resources to help improve the world, and give back to their community's employees. Millennial and Generation Z employees consider social responsibility a priority in the workplace. They are known to want to make a difference in the world by where they work. For example, Dan Price, the CEO of Gravity Payments, chose to take a significant pay cut in order to increase his employees' salaries to $70,000. Over the past few years, the company's revenues and profits have increased, and they have maintained a 91% employee retention rate after the move to increase employee salaries.
So Chapter 5, criminal liability. This is really important for businesses to know, and this will help them out because this will give them a base for their knowledge of their constitution and their laws. A lot of the crimes that happen between business people would be the white-collared crimes. These are the people who deceive, conceal, and violate the trust. There's a lot of fraud that goes on, which is intentional misrepresentation of facts for monetary gain. And this is according to the OpenStax. There are several kinds of these white-collar crimes that businesses should be aware of, and that's the pump and dump schemes, like inflating stocks and prices, and then the Ponzi schemes, like the pyramid schemes, and then larceny and embezzlement. These are just saying a fancy way of stealing. Environmental crimes is a pollution or air to the air, water, or any endangered species. Another thing is antitrust violations that promote market domination. Another one that businesses need to watch out for would be racketeering, which is the money laundering that goes on, and loan sharking and blackmailing. a lot of the times businesses have to deal with these white collared crimes. So if they're aware of these, then they can know what's going on and they can take care of it. I feel like a lot of the times some businesses let this happen and it goes on behind the scenes. And a lot of the times they don't see what's happening because they don't understand it. In Chapter 6, the tort system, this is helping businesses who also commit the white-collared crimes. The tort means wrong. So the tort means wrong in French. This is basically people who are purposely breaking the law. A judge will determine a defendant's duty to a plaintiff, the elements of the defense, and the application of legal rules. A jury will decide what happens, the legal consequences of what happened, and the damages suffered by the plaintiff. Basically, this is who did wrong in the situation. The intentional torts carry purposeful desire to harm, and this can include assault, malicious prosecution, defamation, like slander, and invasion of privacy. Businesses have a duty of care when there is a special relationship, such as caring for people or children. Workers in business are deemed negligent if they could have predicted their actions and would end up breaking the law, but they could be exempt from the negligence under strict liability, such as extreme sport or if someone has trespassed. This is really important for businesses to know the tort system so they know which business is doing wrong. It would be difficult to prove a tort violation if a company could make the defense that its buyers assumed an assumption of risk or misused its products to do something they weren't intended for.
Chapter 8, Sales Contract. The UCC is a large set of laws governing sales contracts between all 50 U.S. states and territories. It is divided into parts, articles: sales, leases, negotiable instruments or commercial paper, bank deposits and collections, fund transfers, letter of credit, bulk sales or bulk transfers, documents of title such as bills of lading, investment securities, and secure transaction. How understanding and knowing the UCC help a business be more successful? 1. Avoid disputes and possible litigation with suppliers and customers. Avoid monetary losses stemming from issues covered by UCC. Avoid business liens stemming from issue covered by UCC. Having understanding when entering into a sales contract.
Chapter 9 is all about employment law and labor laws. Sometimes people get employment laws and labor laws confused and think that they are the exact same thing, but in fact they are sort of different from each other. Employment law covers all laws, mandates, and regulations that are to be followed in regards to an employer and employee relationship. For example, the Americans with Disabilities Act bans employers from hiring, firing, or discriminating against any potential employee or employee based on a disability. The Workmen's Compensation Act, employees can claim compensation for workplace injuries, which is another example of an employment law. Another example is the Civil Rights Act of 1964, Title VII, which bans employers from discrimination in the process of hiring, firing, and promotions based on race, gender, sex, national origin, or color. Another example is the Occupational Safety and Health Act of 1970, or OSHA, which governs workplace health and safety. Another example is the Fair Labor Standards Act, which describes fair and unfair labor practices and covers child labor and minimum wage and overtime requirements. As you can see, these are employer and employee relations. This is different from labor laws because labor laws deal with laws regarding organized labor, unions, and collective bargaining. For example of a labor law is the National Labor Relations Act of 1935, which recognizes the right for employees to form, assist, and join labor unions and to participate in collective bargaining agreements with employers. Another example, the Worker Adjustment and Retraining Act, or WARN Act, of 1988 states the requirement of employers of 100 or more employees to give at least 60 days notice before closing up business or laying them off. The last example I'll give you for a labor law is the Norris-LaGuardia Act of 1932, which outlaws employee contracts preventing workers from joining unions or collective bargaining agreements. Employers should follow these laws because it can help make their businesses successful, because it helps prevent costly lawsuits by current and past employees for violations of these laws. Second, it preserves company reputation to consumers, investors, and future employees. And lastly, it preserves employee relations and helps keep employee morale up.
All right, so Chapter 10 covers government regulations. It talks about administrative law. Administrative law is also referred to as regulatory and public law. It grants administrative agencies to carry out specific functions. Specific agencies have been around since like the founding of the United States, and with industrialization and economic changes, the government realized that it needed to expand its regulation to protect the public. Some of the agencies include the FDA, the Food and Drug Administration, which regulates food and medicine, the Federal Trade Commission, the FTC, which regulates trade, the Federal Reserve System, it regulates banks, and the Environmental Protection Agency, the EPA, which protects the environment. So overall, these agencies were developed to protect the consumers and the community. So how does knowing the content help a business be more successful? Well, for one, businesses have to maintain ethical business practices to ensure that the public is safe using their products, especially if the business is in the food and medicine field, where consumers are putting the products into their bodies and consuming, and consumers need to trust the business to continue buying from them and supporting the business. In addition, following the law of the EPA will allow business to understand how they are impacting the environment and ensure that they are protecting the greater good of the planet, their geographical areas, and the health of the people. When consumers see that the business cares about what they are putting into the environment, they are more likely to continue supporting that business, which will in turn help it become more successful. So if you think about it, would you support a company that is dumping toxic chemicals into your drinking water or polluting the air that you breathe? You probably won't. So think about these aspects will help build a more successful business by having a trusting relationship with your customers. And then on to Chapter 11. Chapter 11 talks about antitrust laws. So antitrust laws regulate economic competition to maintain fair trade practices. They were created to prevent restraints on trade created by trust and other large company practices. There are three main antitrust laws. The first one is the Sherman Antitrust Act. It focuses on trade restraints that were considered unreasonable, such as price fixing. This does not mean that companies can't lower their prices to outsell their customers. It is when a company suppresses other businesses to compete, like forming agreements with competitors to set prices so one can profit, and then they alternate so the other one can profit, and it kind of continues. This will violate the Sherman Antitrust Act, and violating this act is a criminal statute, so it will result in criminal penalties. So it's important for businesses to understand this so that they don't violate this law and get in trouble. The second one is the Clayton Act. It focuses on unfair mergers and acquisitions. It established 4 acts. The first one is price discrimination, basically having the same products sold to different buyers at different prices. Exclusive dealing contracts. It requires buyers to purchase only from one business and not competitors. The third one is corporate mergers. Results in acquisition of competing companies. And the last one is interlocking directorates, which is a board of competing companies with common members sitting on each of the boards. So thinking of these 4 acts, it seems like it could be okay, but at the same time, it seems like it could be a little shady. But the 4 acts can only be illegal if they create monopolies or suppress competition. And unlike the Sherman Act, this is a civil statute. So if a business violates the act, it will result in civil penalties instead of prison time. The last one is the Federal Trade Commission Act. This focuses on unfair method of competition and deceptive acts, and this act will be covered more kind of in depth in the next chapter. So again, antitrust laws work to prevent unfair trade practices that can harm the free market. Most importantly, they also work to protect consumers from businesses controlling prices and products. Without the antitrust laws, shelves will have fewer products for consumers to choose from, and powerful companies will be able to control other businesses. Overall, knowing the content I just covered can help businesses be more successful if they pretty much abide by the laws. It is easy for businesses wanting to profit, but by what means? In theory, I believe that it is easy to price fix or merge with other companies to improve products, but businesses have to think about how it would affect the customers, the main source and the building blocks of their business. Also knowing the different acts can help the business succeed just by avoiding violating them. Whether it be a criminal or civil violations, the penalties will be a big impact on the business. So knowing what is considered unfair business practices will prevent the business from getting in trouble with the law.
Chapter 12, Unfair Trade Practices and the Federal Trade Commission. The Federal Trade Commission investigates unfair trade practices from a number of sources, including consumers, businesses, and media reports. If the FTC concludes that there was unlawful conduct, it can pursue voluntary compliances through consent orders, the submission and filing of administrative complaints, or the initiation of federal action and litigation. How understanding and knowing about unfair trade practices to help a business be more successful. 1, having a fair trade practices can help the business reputation and maintain a loyal customer and suppliers for the long term instead of having short-term gains. Businesses practice fair trade can avoid the negative implication of an FTC consent order, administrative complaints, or federal litigation. 3, businesses can also avoid the time and energy needed to deal with FTC by having fair trade practices.
Hello, my name is Ina Palikchu and I am from Team 8. I will be doing chapters 13 and 14. So chapter 13 is about international law. International law relates to the policies and procedures that govern relationships among nations. The purpose of international laws is to permit countries as much authority as possible over their own international business affairs, while maximizing economic benefits of trade and working relationships with other nations. So the 3 primary sources of international law are customs, treaties, and organizations. For businesses to be successful, the United Nations Treaty was created to maintain peace and security, promoting economic and social cooperation, and protect human rights, especially related to women and children. If you don't know the regulations of other countries and their international laws, you can get into trouble. It could force financial institutions to pay big amounts to revenue services because international laws and regulations are different in other places, and they'll make you pay fees for violating their laws. And without paying, 30% of your earnings and profit are to be taken or held. So to be successful, that's why it's important to also hire and work with the kinds of professionals that are going to be liable and to tell you about these things, and they will hold you accountable so that you and your business does not go under and face penalties. It's recommended, and some actually require, that you do have a lawyer, a tax lawyer specifically, an accountant, secretary, and so on. Yes, it can be expensive, but that's so they're able to check up on these things and counsel you so you don't have to be so overwhelmed with the requirements and comply with the regulations. And the next slide is chapter 14, which is about securities regulation. Regarding the topic of securities and regulations, general regulations are in federal and state security laws. You have to comply with both. If you're paying someone to run a business and gain profit for you, you receive a security right there. The Securities Exchange Act of 1934 has a principle, which is how you make registration of that security and where you qualify for the marketings. Most or all securities done today are done through an exemption. The SEC, which is Securities and Exchange Commission, regulates securities laws and regulations. The SEC also oversees private organizations that create and enforce industry standards. They have the ability to regulate all aspects of securities. If you violate the securities and do not comply with the regulations, you are disqualified from offering or selling securities in the future. So to be successful in your business, businesses must stay current with changes in securities laws that impact their liabilities and responsibilities. The Exchange Act allows the SEC to make new laws. And a successful company needs capable legal counsel to help navigate the compliance requirements of the SEC. And that was chapter 13 and